Hi, thank you for participating in today's webinar, Immigration and Visa Implications of First Amendment Activity by International Students and Scholars. I want to start off with just a bit of housekeeping. This webinar is being recorded, and the recording and the slides will be available on the NAFSA website in a few days. You will see on the slide the web address to find this information on the NAFSA website. We have two main discussion topics today. One, the legal context of protest activities and the potential adverse immigration consequences for non-immigrant students and scholars. And two, regulatory and CVIS requirements that may result from activities that are not necessarily covered by the First Amendment. As you have questions, please submit them in the Q&A box. Now for brief introductions. I'm Heather Stewart, NAFSA's Counsel and Director of Immigration Policy in the Public Policy Department. I am joined today by two experts, we're very lucky, Rena Gandhi and David Fosnack. Because their bios have been shared with you when you registered for the webinar in the reminder emails, I'll only briefly cover their bios, so much more about them. Rena Gandhi is a partner at the law firm of Murray Osario, and she has in-depth knowledge of the intricacies of immigration law and policy. Rena is also an adjunct professor of law at the Georgetown University Law Center. David Fosnacht is NAFSA's very own Director of Immigration Practice and Resources and editor of the NAFSA's Advisor's Manual, which I hope many of you use regularly. I'm sure you do. Can we move to the, you know what? I cannot see the slides. Thank you. All right, can we move to the next slide? All right, the First Amendment to the Constitution. We often hear reference to the Constitution and the First Amendment. It is often misunderstood. Rena, do you think you could give us some background and some understanding of what protections are covered by the First Amendment?
Yes, certainly. First, thank you for inviting me to speak today. I do apologize for my voice. I'm a little under the weather. So first, I think what's important to keep in mind is that the First Amendment is specifically and only preventing government actors from taking action against someone from expressing their opinions, with limitations really only for inciting violence. The classic case law example is shutting fire in a movie theater. So what this means for your members is that in a public university context, this rule applies equally. So a university may provide a narrowly tailored limitation on time, place, and manner, but can't determine what a student is or is not allowed to express. In a private university context, though, they're not bound by the First Amendment unless the state law specifically states so. I'm not a con law expert, but from my research, I saw that California does apply First Amendment equally to private actors within the state, universities within the state, or due to the university's own policies. So there is a difference between public and private. Time, place, and manner is more specifically where a protest can occur, when, maybe how loud it can be, but it can't be fully limiting students from expressing themselves. Um, uh, it also is not for private actors to prevent speech from being spoken. It is specifically for government actors. And I think that's a commonly misunderstood aspect of the First Amendment.
I think you're spot on there. Could you provide some examples of activities that may be considered unlawful, such as what would be considered civil disobedience or trespassing?
Yeah, absolutely. What we might classify as civil disobedience, the law might classify as trespassing or unlawful encampment or conduct constituting harassment. So, for example, a sit-in, while those students may be welcome to and allowed to express their views, a sit-in likely violates a number of policies, safety policies, time, place, and manner policies. So sit-in would generally not be allowed, but I think that's kind of the point of a sit-in, right? It is civil disobedience. For example, an unsanctioned gathering that turns into perhaps rambunctious or violent, that would, of course, violate many different laws, potentially, assault, um, trespass, harassment, uh, things along that nature.
That's great. Thank you. Um, Oops. You jumped ahead one too many slides. Okay, oops. Matt, could you put it to the next slide, please? Moving on to the potential adverse immigration consequences. Unlike US citizens, non-immigrants may face potential immigration status or visa challenges based on arrests or other legal actions. How can an arrest for an activity that may not be protected by the First Amendment impact someone's immigration status? And does it matter if it's a misdemeanor or a felony, or if someone is convicted or not?
So,
That was a lot.
unfortunate, that's okay. Unfortunately for immigration law, or unfortunately for foreign nationals, immigration law is not consistent with criminal law. So in immigration law, something may be classified in criminal law as a misdemeanor, but because of certain factors such as the length of the sentence, such as the amount of time given in jail, um, it can be considered an aggravated felony. So even if criminal law considers something a misdemeanor, the classic example being assault, it could potentially have greater consequences on the immigration side. So for immigration purposes, we don't look necessarily at misdemeanor versus felony. We look at if it qualifies as a crime involving moral turpitude, which is a definitionless section of law, or an aggravated felony. Either one has varying degrees of consequence. A crime involving moral turpitude is, I think, what we would consider a lesser offense, more akin to a misdemeanor, although they're not really parallel. And even a crime involving moral turpitude can have a negative impact on someone's status. There's also a consideration of whether the student is physically in the United States and intending to remain in the United States, perhaps renewing their F1, changing schools, something all within the United States, or if they are traveling out and needing to go to a consulate. So one of the questions I believe, Heather, you asked was whether it mattered if they were convicted or not. And the answer to that question is it shouldn't matter unless they were convicted. However, consulates can take into consideration arrests even if there wasn't a formal conviction. So consulates have a much greater discretion in determining whether someone is likely to be a danger to the community, likely to have immigrant intent, etc., that USCIS within the United States may not take into consideration. On the slide, I can't remember now, I'm so sorry if you asked the question or not, but on the slide it asks about consequences of a conviction versus maybe a plea bargain. So when someone, and I think criminal defense attorneys are always trying to get a case either what's called null pros, which is sort of like an agreement to not prosecute, but that usually comes with certain concessions from the defense side. And these can include the client pleading guilty, the foreign national pleading guilty. For immigration purposes, where a foreign national has admitted to the elements of a crime, even if they are not convicted, immigration can still consider that a conviction for immigration purposes. So when accepting a plea deal, we do have to be careful to make sure that we're not admitting guilt, pleading guilty or no contest, and what are the consequences, community service, probation, um, finishing a Alcohol Anonymous course, what are the requirements, the constraints on the foreign national's liberty that are being imposed? Because even if the ultimate criminal case is dismissed, it can still have a negative impact on their immigration case.
So I'm hearing that there are visa implications if they go abroad and they need to apply for a new visa. And there could be consequences within the United States, maintaining their status and being able to later adjust status or change their status to another non-immigrant status. It could come up at that point as well, correct?
Absolutely. So almost every single immigration form asks if you've ever been arrested. And that is typically a separate question from have you ever been convicted? Have you ever received any constraints on your liberty? So even an arrest would have to be reported, even if the case is ultimately dismissed, and it would have to be explained. And that explanation and what happened during that case can have a negative impact on that claim.
That's great for sharing that information. Thank you. On the content-based restrictions and consequences, there's a section that speaks to foreign terrorist organizations, whether it's material support or other types of support. Can you discuss that a bit? Is there a list of foreign terrorist organizations that the government keeps? Is that something that we can access?
Absolutely. Actually, the State Department has a very handy, if you want to call it that, list available publicly online. We refer to it often in the asylum context. But yes, the State Department has a list. There's also an archive because if a person has provided what's called material support in the past, even if they are not presently, that can also have a negative impact. Um, you didn't quite ask, but it may be helpful to know what is material support. Um, Unfortunately, there's some bad case law that defines material support fairly broadly. Material support can include donations, it can include providing food, shelter, even under duress. So unfortunately, there is some bad case law on what is material support.
That's great. One thing we didn't discuss is deportation risks and removal proceedings. I don't believe that comes up much for the international student advisor groups, but if you could just touch on that just a bit.
Absolutely. I think um, for international students, because they are in lawful status, for the most part, unless they were to have a conviction, generally the issues are being contained with USCIS and with the consulate. However, if they do have a conviction of something potentially more serious, assault, or something along that nature, um, they can be placed in removal proceedings. Deportation or removal are two words that mean the same thing. So for removal, we are looking at whether or not the student is in lawful status. So if they are not in lawful status because perhaps their F1 has been terminated or they've been expelled from school or something along that nature, they can be placed in removal proceedings even without a conviction because they are not in lawful status. If they are still somehow in lawful status, but do have a conviction, that conviction then may lead them to removal proceedings if it reaches a certain level. For example, an aggravated felony or two or more crimes involving moral turpitude.
Great, thank you so much. I think we'll turn over now to David Fosnocht. Can you please give us insight into reporting requirements in the regulations and in CVIS when an international student or scholar has had an encounter with law enforcement?
Sure. Thanks. It's a pleasure to address everybody today. I'm going to take a step back even before CVIS. Rena had mentioned the fact that certain government forms, and in this case, I'm showing an example of the form DS-160, the non-immigrant visa application, just ask the question. The question on the DS-160 is, have you ever been arrested or convicted for any offense or crime, even though subject of a pardon, amnesty, or other similar action? And if you were arrested, you have to answer yes. And this is something that follows you. It's not just have you recently been arrested. It's just an open-ended question. Have you ever been arrested? As Rena also said, how that question, you're also invited to explain that arrest or that encounter with the criminal justice system. And it before filling that out, a student, an applicant who has been arrested in the past or convicted, would do well to consult an immigration lawyer to find out and discuss uh, what the parameters are of the question and how they can respond accurately and but still in a way that helps the consular officer dispose of the issue and still grant the visa. So other immigration forms in USCIS forms, they ask the question, have you ever been arrested? So it's a similar inquiry, and it gets to eligibility for immigration benefits. So I want to continue the practice of taking a step backwards because a lot of what I'm going to go over today does not have anything really to do with consequences of exercising free speech and First Amendment rights. These are applicable to anything that might lead students to to interrupt their pursuit of full course of study, an exchange visitor from doing their research, and so it's kind of content neutral in a sense. So this statute requires schools, institutions of higher education, to report to DHS any disciplinary action taken by the institution against the student as a result of the students being convicted of a crime. The wording's a bit different on the J exchange visitor side. Exchange program sponsors have to report any change in the exchange visitor's participation as a result of the exchange visitors being convicted of a crime. So that is kind of an important language distinction. You have to words matter, and the words in laws matter particularly. So. In this case, there are two parts. One is disciplinary action, and the other is conviction. So this has nothing to do with an arrest. It doesn't require the school, in this instance, this particular provision, to report arrests. But if the student is convicted or the exchange visitor is convicted, then you have to go to the next line of analysis to determine whether the institution is taking disciplinary action as a result of that conviction. And in the case of the exchange visitor, you have to analyze whether or not there's been any change in participation because of that conviction. So this is the DHS regulation that implements that part of the statute that we just covered. You'll see in that sub paragraph D, the wording virtually mirrors the statute, that schools have to report within 21 days certain events, including any disciplinary action taken by the school. So again, you have to do that two-part analysis to understand whether or not you have the obligation to report anything to SEVIS. A conviction alone is not enough in this case. It has to be that the school has taken disciplinary action as a result of that conviction. If so, then there's a place in SEVIS for you to do that. There's a checkbox to say that the student has had disciplinary action taken as a result of being convicted of a crime. Don't ignore one part of the requirement and pay attention to the other. It's both. And you have to provide an explanation. This explanation is you should explain why, what happened and why. On the J reporting side, it is a bit broader. So the J program sponsor is required to let the Department of State know on or before the next business day of any serious problem or controversy that may bring the Department of State or the exchange visitor program into notoriety or disrepute. And There are some examples in the regulations, but they're not very instructive. The Office of the Department of State's Office of Private Sector Administration, OPA, has developed a reporting rubric that contains details of and procedures for making these kinds of reports. One example of an incident in the OPA rubric is an incident involving the criminal justice system. So here it is arrest, charges, incarceration, detention, or other law enforcement involvement. So that's quite broad. There is a form that exchange programs are required to use or highly recommended to use to report these incidents. And again, it is much broader. It doesn't matter if it is a conviction, anything involving the law enforcement would probably be ripe to be reported. And the Department of State they're thinking, they want to know about it from you first. They don't want to read about it in the newspaper or hear about it in the news or read tweets, any social media reports of things. They want to know up in advance. Now, making this report does not do anything to the exchange visitors SEVIS record. Just like the reporting the disciplinary action taken as a result of committing being convicted of a crime, making that report doesn't change the F1 student's SEVIS status. Other things do change the SEVIS status, though. There's a whole host of what are possible disciplinary actions. So it can include things like expulsion or suspension, a determination that the honor code has been violated that leads to one of these consequences. And so when a student, for example, an F1 student is suspended, action has to be taken. You would do well to refresh your memory of what the SEVIS termination reasons are. The SEVIS Help Hub has an explanation, and it gets into what are the uses. When do you use these things? The termination reason suspension in the SEVIS Help Hub says, use it when the student is suspended and unable to maintain a full course of study. Okay, so the suspensions it's a process, and there is due process that the student is entitled to. For example, they can challenge a suspension decision. So sometimes the question is timing. When do you terminate a SEVIS record for something like a suspension? The language in the SEVIS Help Hub stating that suspended and unable to maintain a full course of study is instructive about making that decision of when to do it. These types of decisions should not just be randomly made by individual DSOs. It's something, since it is a general obligation, that should be discussed with general counsel, and there should be a policy of at what point in the process does SEVIS action take place. It's also an opportunity to not wait until an event happens to develop a policy. Explaining the consequences of a SEVIS termination for something like suspension, for example, should be part of a international office's regular education role and outreach to university administration and faculty. There are also some record-keeping requirements that, even if it doesn't require reporting or taking action in SEVIS, for example, this provision requires schools to keep student records, including the effective date and period of students placed on probation. So even though probation doesn't interfere with the student's study, the school has to retain information about that. And usually this is something that's done through the registrar's office as a matter of course for all students. Again, most of these things track what the school is doing for all students. Here are some J1 termination reasons. You'll see similar things to the F1 termination reasons. You'll see this one, conviction of a crime, as a termination reason on the J1 side. That's probably related to the statute. that we reviewed but the statute says a change in the exchange visitor's participation as a result of being convicted. So there might be, it doesn't specify what level of crime or anything like that. And so you might contact the Department of State if you have questions about the proper use of that termination reason. Regardless, if there is any contact with the criminal justice system, regardless of whether or not there's a conviction of a crime, and regardless of whether or not the CVIS record is terminated, you still need to file an incident report as it's a regulatory requirement. So this is a summary, an attempt at a summary to take a step back. And really it's interruptions to study or scholarly activity. For students, they're required to pursue a full course of study, make normal progress to completing their educational objectives. Scholars are expected to pursue their program of research or teaching, and anything that interrupts this activity might impact the student or scholar's CVIS, non-immigrant, or program status. So an invitation. I know that you all know this, but don't wait for things to happen. Establish relationships with key risk management units on campus, including legal counsel. They should be, policies should be carefully developed in partnership with institutions, general counsel, and other academic stakeholders. So I am going to now open it for questions.
I do see two. Oh, sorry, Heather.
No, go ahead.
I do see two that I think are more relevant that I can answer, and I think there are two perhaps that David can answer. One is, does a traffic stop constitute an arrest? I will cautiously say it does not. However, you have to be careful. What is the actual charge? Does it fall under traffic code or does it fall under criminal code? For example, reckless driving. Reckless driving is often considered a criminal charge, but it may feel like a traffic stop because you aren't arrested, typically, meaning physically put into handcuffs, but it is considered a criminal charge. So cautiously, I will say, no, it's not an arrest, but it does matter if it's actually a traffic stop or if it's a criminal charge. And then the other question I saw was relating to, I think, some kind of vandalism, and the student was charged with trespass, and whether or not that's protected under free speech because it's a political statement. Just as a reminder, free speech is speech. Conduct can be criminally charged or punished. So vandalism, trespass, these are valid criminal charges, whether or not they were being done in support of or in civil disobedience or in support of a political statement. So unfortunately, those are criminal charges, and that student can be negatively impacted.
There was a question too, if a student's visa is revoked based on an arrest, no conviction, what are their options to have the visa reinstated?
Unfortunately, they would need to reapply, right? And realistically, especially depending on what country they come from, how likely is that? I certainly can't give you percentages without knowing more facts. However, my instinct would be to say quite low.
David, there's a question about on-campus disciplinary action.
Right. So the statutory obligation is to report disciplinary action as a result of being convicted of a crime. So this question is, maybe an arrest, and there's some type of disciplinary action, minor or otherwise, taken by the school, and that would not fall in the area of things that would trigger that obligation to make that report through CVIS for an F1 student. Now, if the disciplinary action taken in any ways interferes with the student's full course of study, say you are suspended for a semester, Well, that then you would have to take a CVIS action, and that then would impact the student's CVIS status. When a CVIS record is terminated, then that becomes a piece of information that ICE can use to inquire further. And it may be used to make a determination of the student's immigration status. So it's important to distinguish between academic status and CVIS status and immigration status.
Well, thank you very much. That is a great note to end on. We've reached the 12:30 mark. Thank you so much for your participation. We'd love to have your feedback on this webinar. Let us know if there's areas you'd like us to cover under future events. You can email us at govrel, GOVREL @nafsa.org, or me, Heather.Stewart, STEWART @nafsa.org. Thank you to our presenters, Rena and David. We really appreciate your time. You provided us so much useful information. Thank you to all who have attended. I hope you have a great rest of your day. Thank you very much.